Every factory, mill, and office in this country could well post a cautionary sign next to its front entrance. Warning, working may be hazardous to your health. Rapidly changing technology has been introducing novel and gravely serious threats to the health and safety of our employed men and women.
Mr. Chairman, this bill disregards constitutional due process, puts unreasonable power and authority in the hands of inspectors, many of whom might be incompetent or easily influenced, gives only vague guidelines on what is expected, although penal in nature, and gives ultimate penal authority to the Secretary of Labor.
As you can see, not everyone was excited about the passage of the new OSHA law. However, on December 29, 1970, President Richard Nixon signed into law the William Steiger Occupational Safety and Health Act, which gave the federal government the authority to set and enforce safety and health standards for most of the country's workers. On April 28, 1971, OSHA became law. That was the beginning of OSHA. Every civilization has needed both health and work in order to survive. Back in America's early days, employers realized that safety was part of the job because injuries were detrimental to production. However, safety and health was not necessarily a high priority, or so it seemed. If a person was injured on the job, medical care was provided, and perhaps there was some sort of accident investigation. Later, the lessons learned from accident investigation were used as safety training to help prevent a similar accident in the future. You might say that safety was not quite as sophisticated back then as it is today.
We have to recognize that in 1948, 48 states already had workers' compensation in some form or another. Now, what happened in 1970, OSHA was passed when President Nixon was in the White House. And OSHA made a great impact and influence on safety. Unfortunately, in those days, we had a number of people involved in safety, but we didn't have as many professionals as we have today. We had many amateurs. And although there was a great deal of technology, the plain bare fact is that we didn't have the wisdom to use it all. So management got involved because OSHA was passed. But let me just make this comment about OSHA. Voluntary compliance only represents a minimum, and that means that many companies were practicing minimum safety standards, and we need to excel and have maximum safety around the clock.
Prior to the passage of the Occupational Safety and Health Act in 1970, organizations and safety engineers relied upon voluntary safety standards to guide workplace safety programs. Voluntary standards don't always work, so Congress set into law many of these voluntary standards as law.
One of our first regulations was to require construction workers to wear hard hats. It was fought bitterly both by workers and their employers, but now it's a matter of course. And everyone is proud of wearing them as well as saving lives and injuries. So I'm going to put on my OSHA hard hat. And as you see at every construction site today, but you didn't see 30 years ago.
In 1971, one day safety regulations were voluntary. The next day, they were codified into a complex-looking set of safety standards that were laws. Many employers in 1971 were not prepared for what was the future of safety and health in the workplace.
OSHA had a great impact, together with other organizations, such as the National Safety Council, the American Society of Safety Engineers. But we need to do a great deal more in order to make the workplace, as OSHA states, every workplace must have a safety program and also a health program. And I want to emphasize that health aspect which has been neglected, and we need to do more.
OSHA is basically, at its inception, a collection of codes and standards that were established by the American National Standards Institute, or ANSI. So if you take those codes and apply them with the long arm of enforcement, then you have an application of things that have basically been brought up through a process of review and committee and development by professionals outside the sphere of OSHA. When you introduce those codes and standards, you're looking at a very significant set of minimums that are in some ways compromises to perhaps a better standard that might be possible, but for economic or even political reasons, those higher standards may not be possible in the economic situation of the day. Historically, though, OSHA has shown that it has proven effective in terms of applying judicial fines and financial leverage to ensure that companies are aware of the power of OSHA and the importance of compliance to codes, especially where there has been a code violation and a serious injury or even a fatal injury. So it's a significant value in terms of its overall value in terms of applying law enforcement to safety standards and safety improvement.
Well, I think the best thing is that it has caused the safety ethos, if you will, or the safety ethic to be propagated into smaller companies. Probably the worst thing is that there tends to be an emphasis on complying with standards rather than doing what you can in terms of accident prevention across the board. Now, one of the things that OSHA completely ignores is your routine trips, slips, and falls, which are roughly 40% of any business's accidents, either to their own personnel or to visitors and customers. And that's really a significant shortfall. These days, OSHA is enamored with the exotic things, you know, the chemicals that kill people, maybe by onesies and twosies, and yet the slips, trips, and falls are paralyzing people by the dozens and more or less gets ignored.
Keep in mind, the Occupational Safety and Health Act was conceived also as a response to building on the success of the Mine Safety and Health Act, MSHA, of the year before. In 1968, an explosion and a resulting fire killed 78 men at the Console No. 9 mine at Farmington, West Virginia. Major accidents, such as the Farmington disaster, led to the passage of the Mine Safety and Health Act. In the same heated political climate of the turmoil surrounding the war in Vietnam and social protests about race and the future of American society, the OSH-Act was written and passed in this vibrant and unique social context. Although wary of the needs of small business, opponents stated, "The fact is that many employers, particularly smaller ones, simply cannot make the necessary investment in health and safety and survive competitively."
Well, the first 10 years prior to OSHA, we were all using voluntary standards and ANSI standards. One of the problems was that if an employer felt that the voluntary standards was too expensive to implement, well, they just wouldn't do it. They would take some and they would use some and they would not use others. So it was kind of a catch as you catch can. When OSHA was born, it came into law, there was a big furor because all of these regulations, the small businesses, the large businesses, they said, my God, how are we going to comply with all this? It's just going to be a ton of money going down the drain. So basically, we needed to find a way to comply with OSHA, yet still run safety programs.
What is the Occupational Safety and Health Act? Section 5A1 of the Occupational Safety and Health Act, the General Duty Clause, requires employers to provide employment and places of employment that are free from recognized hazards. OSHA was passed with the express purpose to provide safe and healthful employment and places of employment for every working man and woman in the nation. By providing medical criteria which will assure insofar as practicable that no employee will suffer diminished health, functional capacity, or life expectancy as a result of his work experience. And, according to the courts, to prevent unsafe working conditions, Congress enacted the Occupational Safety and Health Act of 1970. The Act created a new statutory duty to avoid maintaining unsafe or unhealthy working conditions and empowers the Secretary of Labor to promulgate health and safety standards.
One of the really unusually brave parts of the Occupational Safety and Health Act was that Congress understood that there were problems it couldn't really understand and solve. And it gave the Secretary of Labor the power to create rules, but to create them in a way that had never existed before, and to promulgate those rules in a way that it hadn't given the power to an agency before. It actually took 2 Supreme Court cases to try and figure out what that really looked like. It's a process that takes almost 10 years, sometimes 15 years if it's a hotly debated rule. And it's a process that requires participation both by OSHA and NIOSH doing the background research that it recommends to the agency.
The Occupational Safety and Health Act created 3 agencies. The Occupational Safety and Health Administration, OSHA, which is in charge of creating standards and enforcement, which is part of the U.S. Department of Labor. The Interdepartment Judiciary of the Occupational Safety and Health Review Commission, OSH-RC. The independent research arm of OSHA, the National Institute for Occupational Safety and Health, NIOSH. NIOSH is part of the Department of Health and Human Services, also the home of the Centers for Disease Control and Prevention, or CDC. Unlike the EPA and related health agencies, there are no mechanisms for criminal enforcement or so-called citizen suits, although there are no express limits on the subject matter of jurisdiction.
One of the compromises that was made in making the Occupational Safety and Health Act was to limit the right to complain about occupational safety and health hazards to individual workers or their representatives and to OSHA inspectors. And what that meant is that people in the general public who were affected by those hazards cannot complain to OSHA. This is a stark contrast to statutes passed at the very same time in history that gave the right and ability to individuals to complain about violations of law. So, for example, if a worker is in a public place that's privately owned, such as a hotel, the individual worker involved in construction at that hotel may have the right to complain about working conditions such as a loose scaffold or exposure to asbestos that's in the air during removal of a ceiling or walls. But the person who's working in the hotel may not complain to OSHA about that construction hazard, and the individual who may be working and happening to be in that hotel by accident cannot complain to OSHA about the exposure that they face or the hazard that other people face in the process.
One of the most important regulations that OSHA issued was the cotton dust regulation. I'm wearing a hat from Unite, which was the old Act II, the union which represented the cotton textile workers. I have a cotton bowl here and a salt shaker full of cotton dust. There's enough cotton dust in here to put into respiratory arrest a large number of people. In fact, the cotton industry sent us on a tour of textile mills, and their public relations lady walked into the mill and immediately went into respiratory arrest from breathing in the cotton dust in the mill. The regulation has been extremely effective. We've reduced bisonosis rates from 10 to 25% to below 1%. The cost of the regulation was 1/4 of what the industry recommended, estimated, and 1/2 of what OSHA estimated. The regulation actually improved industry productivity. So the regulation was highly effective both in protecting workers and maintaining the competitiveness of the industry.
Part of the regulatory aspects of OSHA is to evaluate epidemiological data to determine how severe the various occupational exposures are to workers. So you need to have people with expertise so they can evaluate the studies, see which are good, which aren't, what are the limitations of the studies, and also then to be able to synthesize the information for the public so that you can clearly express what OSHA is doing to protect workers in a specific standard and how that determination is made.
For us, we spend money on judges. We spend money on deciding cases, getting cases heard. We were talking earlier, part of it is we are a very new and special kind of agency in the judicial system. We were very novel back in 1970, and we were created as a compromise, really. Normally in the federal system, what would have happened is contested OSHA cases would have been heard within the Department of Labor. Department of Labor administrative law judges would have sat as the trial judges for those cases, and then the appeals would have wound up through the Secretary of Labor. Well, everybody back then was kind of really not satisfied with the Department of Labor. At least on the political sides, there were those that were for the department, there were those that were not for the department. And Larry Silverman was a Solicitor of Labor at that time, and Ben Mintz was, I guess, a special operative brought over from the National Labor Relations Board, and they were trying to chart a course through these various fractions to get a bill that would work. And one of the compromises was to say, let's take the whole judicial function here, trial and appellate hearings, out of the hands of the Department of Labor and put it in a special tribunal. And thus the Occupational Safety and Health Commission was created.
NIOSH has been the linchpin of these developments too. NIOSH research goals have provided the financial resources for thousands of investigative studies and in turn have generated the impetus for many research programs in academia that would have never existed but for the government interest in the subject of their work.
NIOSH is a magical, wonderful piece of visionary legislation on the part of the U.S. Congress. They understood that there were problems they couldn't solve and that there was no place to learn how to solve those problems, that not just research and data was needed, but methodologies to use that data, to put that research into practice. And so the U.S. Congress extremely wisely, despite all its loud debate and compromise, agreed that in Section 21, NIOSH would be created, the National Institute of Occupational Safety and Health, with the purpose of creating research, of looking at where that research could be used in standard setting and in enforcement. And one of the magical things that came from that is a whole network of academic centers, the ERCs, that in fact create new research and new places where people can study occupational health.
We at NIOSH are a specific statutory creation. Our job is to generate new knowledge and transfer that knowledge from research into practice globally. Plus, we at NIOSH also, according to the Act, have to give out information and education and build capacity in occupational safety and health medicine and nursing and safety, industrial hygiene, engineering. So we actually have a robust training program for to educate students in these disciplines that our nation needs.
People that work at these agencies are very committed to worker health, and that's a fortunate aspect of NIOSH and OSHA. It's difficult to do a lot, unfortunately, to protect workers in this country because of the economic interests. When you try, you do a study, you find a hazard, now you try to implement that knowledge to protect workers, it's when you take the last step that you start to gore somebody's economic ox and all kinds of hell is going to break loose because industry, for the most part, does not want to pay too much to protect workers, and that's unfortunate.
NORA is the National Occupational Research Agenda, and it's entering its second phase. The first phase was a brilliant idea to bring together researchers, not just from the United States, but indirectly from the whole world, to gain a consensus on the state of the art of the important research NIOSH conducts, and to set priorities, not only for the future, but even using the existing data and the existing information.
When the U.S. Congress wrote the Occupational Safety and Health Act of 1970, it sought to cover a lot of ground in one bold stroke of the legislative pen. Congress sought to reduce injury and illness at work, to preserve our human resources by protecting the health at work of every working man and woman in this nation. The many compromises required to pass the OSHA are reflected in its limited jurisdiction that excludes entire populations of workers in the public sector, in parts of mining, agriculture, and its failure to provide private rights for action by citizens to enforce its tenets when the citizens themselves are not workers who are harmed.
One of the problems in creating the Occupational Safety and Health Act was that there was this fear of federal power at the time it was written. And so one of the ways to fracture that power and keep it smaller was to make sure that the Occupational Safety and Health Act only affected certain segments of the population. Despite the public outcry for protection against industrial disasters, despite the loud debates in Congress, there was a desire to keep the agency's power small. So some industries, such as mining, which has its own statute, and agriculture, which was covered by other agencies, were deliberately excluded from the Occupational Safety and Health Act.
Overall, the OSH-Act has done pretty well for a relatively young statute. Congress, through the authority delegated to the U.S. Secretary of Labor and to NIOSH in sections 21 and 22 of the statute. Safety professional organizations and trade associations groomed the professionals who would create programs for workplace health and safety training. The statutory scheme holds an amazing track record in promoting a wonderful state-of-the-art of the understanding of occupational health and safety.
In terms of setting standards to protect workers, most of the standards that OSHA sets, the industry sues OSHA because it doesn't want to try to achieve that standard to protect the workers. So if they're suing OSHA because they don't like the standard that OSHA has set, if there were no OSHA, there would be no standard. So obviously, there's a benefit to having OSHA to set these standards.
Over the years, there are several states that operate their own OSHA program. Most notably is the California OSHA program, or Cal-OSHA. States operating their own OSHA programs are required to have laws and enforcement equal to or better than federal standards.
One of the really crippling compromises that was made in passing the Occupational Safety and Health Act was the concern about states' rights. We have to remember that the Occupational Safety and Health Act comes from a time when the federal government was asserting power in many areas like civil rights, where it had never shown its power before. And states were going to oppose the federal power in any place that it might show, without regard to the specific law involved. So the states really wanted to preserve their ability to do things their own way. And the compromise that was made was the creation of Section 4, which preserves states' rights specifically, in really a reversal of a typical theory called preemption. Preemption usually says the federal government is supreme, but in the Occupational Safety and Health Act, it's the states' rights that are supreme.
To make sure that an enforcement officer had something to look into, a chapter for each of their activities, to make sure that their behavior conformed with what the agency expected. And prior to my coming to Cal-OSHA, that wasn't the case. Oftentimes employers complained that enforcement procedures were different in Southern California than they were in Northern California. And labor unions complained that they got variable responses when they called offices to file complaints in Southern California, Northern California, Central California. So I think that activity actually took a decade for me to accomplish, with a lot of help from various other people in the OSHA program.
The role of demographic changes in the workforce is one of the greatest challenges facing OSHA in the next century. It has often been said that rising worker compensation costs have generated more enthusiasm for corporate safety programs than has the Occupational Safety and Health Act. Just how well has all the resources for OSHA helped reduce America's workplace injuries over the past years?
I have heard the drumbeat over and over and over again. You have to have top management support. I would add to that top management direction. You can have top management support in the form of a policy or a statement on a safety training video that the employees would see, but I think management needs to demonstrate that. They need to direct it. They need to be part of the management by walking around theory, where when they go out on the shop floor or they're out on the construction site, they put on the safety glasses, they wear the hard hat, they follow the safety rules, just like the hourly worker and the rookie employee. And management by example, safety by example from top management is one of the most effective ways to do it. The other thing I would say is that you could have a number of written safety programs beautifully bound in the 3-ring binder, sitting on the wall. If it never gets opened, it never gets read, it never gets distributed, it never gets signed off by the culture and the attitude and the belief system within the company, then safety never gets done. Safety is 100%. It is an absolute field of endeavor. It has to be safe from the beginning of the new year to the end of the year. The person that comes to work at the beginning of the day has to have the right and the assurance that he or she will leave at the end of that workday without having any incident involving their health or the injury to that person. And I do believe that safety is an absolute goal that we can reach and we should reach, and that is the absolute nature of the safety profession, to make sure we can strive for excellence and achieve a 100% injury-free performance over an infinite period of time.
Do I think money spent by OSHA was effective? No, I don't. Primarily when they first came out, if they had helped the employers, given them more information, posters, training materials, and so forth, it would have gone much smoother. But they came down just like a hammer, and employers had to comply, period. That was it. And that kind of turned employers off quite a bit. Nowadays, they're doing voluntary programs. They're providing information, assistance. You go to their website, all sorts of information. So today, they're probably doing too good. They're probably doing well, but I don't think they're still spending their money effectively. Well, although there are a lot of dedicated professionals in OSHA, compliance officers, people behind the scenes, let's not forget about the American Society of Safety Engineers and all the men and women that are actually safety managers in companies. Sometimes we forget that they've kind of always been on the low end of the totem pole. Now we're up about the middle of the totem pole, and I think with renewed efforts, renewed technology, more professionalism, the safety profession will benefit greatly from the future.
Work is as old as humanity itself. Yet somehow, even after the passage of OSHA and the great pioneering work on the cutting edge of scientific discovery by NIOSH, we don't seem to get the message out to the public. This is the basic mission for NORA, NIOSH, and all of OSHA in the century ahead.
Having NIOSH gives us an agency where we can focus our interests on worker safety and research, for example, on the newly discovered hazard of brominated flame retardants. With NIOSH, we have an agency that we can turn to for research on the effects of these chemicals, on studying how to decrease the amount in the workplace, and compare levels perhaps worldwide in this country and other countries. The only problem with NIOSH is not with the quality of their science, which is excellent. It's with the rapidly or progressively decreasing resources they have for their own work and for the work of those out in the field.
NIOSH has been for many years the provider of the resources that help us to look and determine the necessary elements of a safe and healthy workforce. I think that as we go into this new millennium, and we face the challenges of aging workers. We face the challenges of synergistic relationships between psychosocial stress and comorbid conditions that the workers bring to the workplace, as well as the unique exposures that they face. We have to readjust our sights, and we have to think about how all of these influences come together and have an effect on our worker in order to minimize the risk and maximize the safety.
Outreach to all populations using a classless model that embraces service industries, professional workers such as doctors, architects, engineers, lawyers, and leadership in business and government, outreach using health promotion that embraces the special needs of the changing demographics of our population who will use their experience beyond the 7th or 8th decade of life. And in all categories, people with disabilities, with thanks to ADA and equal opportunity to education, will now enter our workforce regardless of the cause of injury and take their rightful place as employers, employees, and taxpayers, raising the ever-thorny occupational health and safety questions of reasonable accommodations. OSHA and its delegated agencies have made remarkable strides regarding bridging occupational health with the rich empirical data from health promotion, but we have so far to go.
You know, in the first 10 years, and looking at it from the standpoint of developing health standards, there were a lot more health standards that were developed in the first 10 years of OSHA. With the Supreme Court decision in 1980, so that was after 10 years, regulation became a lot more complex because regulations require now quantitative risk assessment, and often the data are difficult, and there's a lot of argument about what the risk is because you don't always have, you know, the exact set of data that you need to do the ideal risk assessment. So it's for those periods of times where you don't have information, how you fill that information in, how you extrapolate to that amount of information to determine what the risk is. It creates a lot of argument, and standards are a lot longer. They take a lot longer to develop, and OSHA, as time goes on, we have a lot more hoops to go through. So it takes much, much more analysis to develop a standard today as compared to what it did, let's say, in the mid-70s.
Regardless of your opinion of OSHA, one thing is prominent. It has increased awareness of the need for safety and health in the workplace. The past is past. Our history begins now. Not only should we recognize the many thousands of dedicated professionals working in government, but let's recognize companies and equipment manufacturers that continue great technological advances in the betterment of health and safety. All the men and women working as safety and training managers in organizations who are dedicated to making all workplaces safe and healthful are part of the future of safety. We've come a long way and have a troubled road ahead, but health and safety is a lofty goal for which we should all strive.